Hello, and welcome to On Point. I'm Mohammed Asad. What will a larger conservative majority on the US Supreme Court mean for the nation's politics? This year, presidential campaign between Joe Biden and Donald Trump for elections was intensified by the death of the Supreme Court Judge Ruth Bader Ginsburg. Ginsburg was a liberal judge. Last month, the US Senate confirmed her replacement with the new Justice Amy Barrett, meaning 6 of the court's 9 justices were appointed by Republican President. Barrett is a Catholic and a strongly pro-life.
As it's going to definitely mean the court's going to shift to the more conservative basis. I would expect that the decisions that come out of the court on anything like abortion, immigration, crime control, a lot of these are going to have a much more conservative perspective. But the one thing that you have to always keep in mind, and I always come back to it when I teach courses and I talk about this, is that the justices are there for life. And just like you and I and our political philosophies may change over time, so do justices.
Democrats fear the justice's religious views may interfere with her decisions. They're most concerned about how she'd rule on a challenge to the famous Roe v. Wade decision, which effectively legalizes abortion in America. On Point's Alexia Mersola has more on the story.
Thank you, Mohammed. Today I am speaking with Professor Bruce Zucker, an Associate Chair of CSUN's Criminology and Justice Studies Department, Kimberly West-Faulcon, a Professor of Law at Loyola Marymount University, and Bertrall Ross, the Chancellor's Professor of Law at UC Berkeley. Welcome, everyone, and thank you for joining us. So when asked by Lindsey Graham during her hearing if she would be able, so this is Amy Barrett's hearing, if she would be able to put her Catholic beliefs aside on any issue before her, Barrett said she had before and would continue to do so. So my question for you all is, do you all believe she will be impartial in any area she will come across as a Supreme Court justice? Let's start with Professor Ross.
Yes, thank you. I think that one thing to understand is the difference between impartiality and neutrality. I think that she will be impartial in the sense that she will not be favorable to one party over the other in a particular case or in a particular matter. I don't think that, I trust that she has the ethical motivation that would lead her to be impartial. Mm-hmm. But neutrality is a different thing, right? Neutrality on the issues that will confront her, I think it's unlikely. I think it's unlikely for any judge or justice, because when your main responsibility, as it is for justices on the Supreme Court, is to interpret the Constitution, and the Constitution is quite ambiguous and vague, and values will inevitably influence how these particular individuals will decide cases. And so while she may try to be neutral, I think that her values and her interests and her orientation will influence how she understands and reads the Constitution. And I think it will influence how she engages in other cases in the criminal law field and in other fields as well. So I think that would be too much of a demand on any particular justice to say that they'll be neutral, but I think that her conservative background and orientation and grounding in the Catholic religion will influence her decisions.
Okay. What about you two? What about Professor West-Faulcon?
I certainly agree with Professor Ross, and I would add that I try to encourage my students and folks when I'm trying to talk about how we would like to distinguish between public policy questions, what you believe the world should be, what your opinions are about matters of faith, that those are issues that are distinct from questions of law and legal doctrine, the rules of law, and they're also distinct from questions of legal theory. Your theory as to how you should decide the meaning of a particular provision of the Constitution. That said, justices, as Professor Ross just articulated, have a belief system, have ideologies, have points of view. And while I would never purport to know whether someone is in their heart of hearts honestly saying, I can be neutral, I can be impartial, there's absolutely no question that Justice Barrett has particular belief systems and ideological belief systems about the role that the Supreme Court should play in our society, the role that the First Amendment should play in relation to other provisions that protect individual rights, And so if I am completely frank, which I am inclined to be in 2020 in a way that maybe I'm a little more delicate in prior years, while every justice is supposed to pay lip service to a mantra that we like to hear, I will do policy. I will not do policy, I will do law. I will not do policy. It will not be, I think she said, the law according to Amy, to give us comfort. The reality is our lives can change incredibly simply because she has a particular theory of how she interprets the Constitution without it ever needing to be labeled policy. So I honestly don't think it's really very relevant whether she's honest about that statement or not. She has a very clear and predetermined record on the meaning of the Constitution that is really the major issue and the major reason to be concerned about her addition to the court.
Professor Zucker, would you like to add to that?
Yeah, I concur. I think, and thank you. I think in full disclosure, I think it's important that my background, I think I'd be described as a liberal as opposed to a conservative. I represent, I still do a lot of pro bono, habeas corpus, false conviction, prisoner's right kind of stuff. And it just forces me into that kind of way of thinking. Now, with that said, and that full disclosure, when I look at the Supreme Court and I look at these major decisions coming down, I'm looking at it from that angle. And I think, if you look at who the court is now, and you look at where Judge Barrett, now Justice Barrett, has been, you have people, everyone's talking about, RBG and the loss of RBG for the liberals. And she's done a lot of great stuff on that side. And then you have people like Clarence Thomas and a Bush 2 appointee named Alito, more on the right side. And they, you can kind of predict sort of where they come out on the major policy, what was discussed by my colleagues about policy and whatnot. But where I find it's interesting is a couple of things about Justice Barrett. Number one, we know that she comes from the Fifth Circuit, and we know that on the Fifth Circuit, she's been studies that have tracked the liberalness and the conservativeness of her decisions. We know that she's come out like all the way to the right. Okay, so we know that that's like a starting point with her. We also know that she's, some of her decisions are, not always a so-called conservative decision. She will sometimes rule in a more liberal bent, if you're going to do this in a binary sort of definition. What tells me a lot, and what I'm hoping, I guess, about her, she's a disciple of the late Justice Antonin Scalia. And Scalia, although by no means is considered a liberal, he was to the right. He wasn't as far to the right as people like Clarence Thomas, who's proven to be, I think just somebody who, his whatever the most right-leaning way to decide something, he will go that direction almost always. But Scalia is interesting, and Scalia has surprised us, particularly in the criminal defense arena. He's brought us some landmark decisions. I don't want to get too technical for our audience, but there was a decision about 10, 15 years ago called Crawford. And Crawford addressed the Sixth Amendment right to confront and cross-examine your accusers at trial. And Scalia blasted sort of the conservative bent on that and created this decision that basically undid the U.S. sentencing guidelines and made them no longer mandatory but permissive. And that came from a conservative side, and it came from a disciple of Scalia. I mean, it came from Scalia, and she's a disciple of Scalia. Mm-hmm. So, and then finally, my point is, and my colleagues probably know this well, it's kind of a joke, once you appoint someone to the Supreme Court, you have no idea what they're going to do. I mean, Roberts, Bush 2 appointee, goes to the middle. Kennedy, a Reagan appointee, made some decisions with the liberals. So we don't know how much she is going to move away from her conservative beginnings and how much that's going to influence what she ultimately does.
That's very interesting, actually. Because I think playing off of my question, Scalia was a Constitution originalist. Will that affect her decisions?
I would say that it is unquestionably significant that she's a particular kind of originalist. Originalism comes in many flavors, maybe so many that it doesn't even warrant being deemed a coherent or consistent theory. But Scalia's form of originalism is Amy Coney Barrett's form of originalism, and it's called original public meaning originalism. And it is striking because of how non-constraining it is. It sounds great to the lay person, but it operates in such a way that the judges who are implementing it have an immense amount of power. And what is, I think, the most common misconception about originalism as practiced by Justice Scalia and modern originalists is people think it is what it sounds like it is. They think it is the specific intent of the framers. They think it is, let's delve in and find out what James Madison would have thought or would have thought this provision should mean. And what, again, the average lay person, I think, doesn't know, and there's no reason for them to know it, and I think it's pretty purposeful to hide it from folks, is that it is a very different endeavor, and that it's an endeavor that involves digging into very explicitly old dictionaries, old law review articles, and even in some instances, old newspaper editorials. I mean, this is literally what original meaning originalists use to decide, as Professor Ross was saying, what an ambiguous provision of the Constitution means to him or her. The reality is, it is a way to cover up a lot of your ideological beliefs, a lot of things that you may not in your own mind know is dictating why when you pick up that old dictionary, you read the Second Amendment a certain way. And if maybe I picked up that same old dictionary, I might have a different view of it. So it honestly really hides all of the discretion and power that judges are exerting anytime they interpret the Constitution. So original meaning originalists, non-original meaning originalists, the traditionalist approach to the Constitution and interpreting it all mean that whoever is doing that interpreting is going to have a tremendous impact on our lives day to day. But what is very stealth-like about these original public meaning originalists, they try to make us feel very comfortable about what they're doing by putting this real facade on it and labeling it something that, again, you think they would care if we had a seance and brought the framers back. But what I'm always telling my students is that Justice Scalia is not coming to the seance. And they're like, are you serious? He does not value the intent of the framers as a legitimate source of meaning. And it takes a long time for that to really sink in. But if you ever get a chance to be in a room with an original public meaning originalist, just ask them, remember it. Are you coming to the seance? If James Madison appeared and said, this is what the Second Amendment means, would you abide by it? And their answer is no. And that's the same for how Congress interprets statutes. They do not abide by and do not value what those who write federal laws say they mean. So it is immensely significant that these people have these approaches, because it means that as they join the court, I think all bets are off. But I'm curious to hear what others have to say.
So we're talking about abortion rights and what's at stake now that there is a more right-leaning Supreme Court. So this is, again, an open discussion. So my first question is if Roe v. Wade is overturned, what happens next? Does abortion become federally illegal, or will it be up to the states to decide?
So just to understand what the lay of the land is and what Roe v. Wade did. So the lay of the land in terms of prior to Roe v. Wade is that there were certain states that prohibited abortions, and there's variations in laws that could have prohibited abortions in all cases and in a certain range of cases and such. And what Roe v. Wade did was constitutionalize reproductive freedom that provided protections for women to choose to to choose to have an abortion, and there's a different standard and test that's applied to it, that's applied to laws that seek to restrict it, and some laws would be allowed, but many laws would be prohibited under Roe v. Wade. Now, what happens after Roe v. Wade? Well, there's variations again with respect to laws on the books, but you cannot absolutely prohibit abortions in certain contexts, and I won't go into the details of that. But what I'll say in terms of if the court were to overturn Roe v. Wade, what would happen? Well, that would mean we would return to the status quo that existed before Roe v. Wade, in which it would be a state determination as to whether and to what extent women would have reproductive freedom. And certain states would make different choices. California would make a different choice than Alabama. Biden has suggested on the campaign trail that he would seek to pass a federal statute that would protect the right to reproductive freedom. Now, whether that statute would be held constitutional by the Supreme Court is an open question, but that's where we are with respect to Roe v. Wade.
From a legal standpoint, would places that offer abortion clinics like Planned Parenthood be able to fight the Supreme Court if they do overturn Roe?
If the decision is overturned, and it depends, because Roe is a 1973 case, and several years later in the 80s, we started as the court shifted from the civil rights era, from the 50s and 60s, the Earl Warren Court to the more conservative Reagan appointees like Scalia, Rehnquist, and Warren Burger, we started seeing it chipping away. But I think there's also something to keep in mind, and I've thought about this a lot since unfortunately, Ruth Bader Ginsburg died, and has been a champion of the rights of women's rights and all of this, and one of the few left. Roe versus Wade is built on this idea that started with cases from the 60s, a case called Griswold versus Connecticut that talked about privacy. And Roe was built on that, and then other cases followed, like Lawrence v. Texas and some of the other cases, Lawrence v. Texas having to do with the right of two men to engage in intimacy. But it all stems from not an amendment to the Constitution, not a law. It stems from what Justice Douglas once said as the penumbras of the Constitution, meaning if you look at certain amendments in the Constitution, like the First Amendment's right to free speech, and the Fourth Amendment right to be free of search and seizures, and the Fifth Amendment right against self-incrimination, there's an unstated right of privacy. And what the conservatives are saying, the conservative justices are saying, is Roe was improperly decided. It was improperly based on this line of cases, and it's bad law. And what we can see happen, and what could very likely happen, is and Justice Barrett has said this, in certain, she was asked, are you going to respect precedent? Because Roe is precedent. And her answer was, well, there are certain cases that we would, but like, she didn't say it just like this, but essentially like Brown versus Board of Education overruled Plessy versus Ferguson because it was just inherently wrong. She could be taking the position of Roe was wrong. It was wrongly decided on the law, and it was wrongly decided in morality, or whatever she decides, and they decide, and it throws it back. So what would happen? And if there is no federal protection, the only thing that can protect privacy and the right to choose would be an amendment to the Constitution. And that's really what needs to happen.
So we are going to move on to another topic. Thank you guys for answering. So this topic is on gun policy, specifically what Barrett has said about gun policy. So in the U.S. currently, convicted felons possessing firearms is illegal, but Barrett has written that violates the Second Amendment. From a legal standpoint, is that true?
I'm going to try to weigh in a little bit on the last topic, and
okay, no worries.
And also transition. I think what I do want to comment on with respect to the fundamental right to terminate a pregnancy pre-viability, I like to put all those things there because that's what Roe v. Wade held. That is what is at stake is a provision of the 14th Amendment, its due process clause, that contains the word liberty. And I was just telling my students this morning that if only they called it freedom analysis instead of substantive due process analysis, again, we could explain it to more lay people. Because that is what the Supreme Court has interpreted in that line of cases. Their autonomy cases, whether it's sexual autonomy, reproductive autonomy, family autonomy, marriage autonomy, but it is the Supreme Court reading into, yes, it is one word. So these are unenumerated, non-textual fundamental rights, but it's one word that has a big meaning. It's liberty, it's freedom. So it is really the court interpreting what are the limits of the government's power to regulate your life. And when people conceive of it that way and hear the actual facts in Griswold, which is the state of Connecticut saying to married people, not to mention single people, it will be illegal for you to use contraceptives in the privacy of your bedroom, it's a lot more ominous to hear that Justice Barrett now thinks that that case is wrongly decided. It is the government regulating the most intimate aspects of your life. And how do you reach that conclusion? It is using original public meaning originalism and saying, when I use my method of interpretation, I can disregard decades and decades of precedent and now overrule and take away rights that prior iterations of the Supreme Court have felt are absolutely part of what freedoms and liberties you have as a citizen and as a person in the United States. And I can change that, because I do not believe in the principle of stare decisis, even as much as my mentor, Justice Scalia.
So what is stare decisis?
Stare decisis is the principle that the Supreme Court will abide by its already decided cases, that it will conform to those, and that it would be only in extraordinary or unusual circumstances that the court would overrule its prior precedent. I think Justice Barrett is much more like Justice Thomas when it comes to precedent. And Justice Thomas has long been the outlier on the court who has been quite willing to disregard prior precedent. And so I think that's the thing to be concerned about and to watch with Justice Barrett, that while Justice Scalia would snark and be sarcastic when he criticized cases with which he disagreed, he had still at least paid lip service and went through the doctrinal steps of overturning precedent. But what we have now is a set of justices who are much more extremist in that they are not even really willing to pay lip service to the principle of stare decisis, but have really already announced that it will be their intention to take the big old constitutional law books and we can essentially rip out pages and pages and pages. And that's going to be our fundamental rights, probably, given their plan. And that is a very stark and significant decision. By contrast, though, the Second Amendment, they say, well, we're going to treat that differently because it's part of the Bill of Rights. It's a textual right. We can say that the words of the Second Amendment delineate that it is always going to be there. So the perversity will be that we'll lose certain rights, we'll lose these autonomy rights, and the right that many of us associate with being free from government regulation, but then there are going to be other rights that they're willing to lift up way beyond even what Justice Scalia said in DC versus Heller. So what is striking about both Justice Kavanaugh and Justice Barrett is that they both have been willing to be more extreme in what they say the Second Amendment means than even Justice Scalia. That Justice Scalia was very clear in DC versus Heller that there are some very basic reasonable gun regulations, such as if you have convicted of a felony or you have other reasons the government should be very concerned about you having a firearm, or if you're going to have it in a place like a school, that it's in the text of DC versus Heller to say that, sure, the government still has the power to regulate in that realm. Where Kavanaugh and Barrett have been willing to go is to take words in DC versus Heller, the combination of, well, if it's a unusual weapon, Justice Scalia said, then you don't really have a right to have it. But Justice Kavanaugh, and again, I think Justice Barrett is willing to do something very similar, is to say, well, if a lot of people have the weapon, it's no longer unusual. That's an approach that could mean that the most dangerous assault rifles, if enough Americans were to buy them, we could live in a dystopian America where people are walking around everywhere with assault rifles. Sadly, for some Americans, what I just described is not dystopia. It is what they see when they walk out of their homes. So I do not think it is a correct interpretation of the Second Amendment, but it is certainly where the doctrine is heading. So we are also going to have to go into a realm of where you're going to have some scholars saying, well, this is what the law is. But that's also, I can tell you that if I were to tell you what I think the law actually is, when it's correctly interpreted, I would say we're going to be living in a world where there is a disconnect between the two.
Okay, and unfortunately, we are out of time. I know that was a lot of stuff to cover in a small amount of time. Thank you, everybody, for joining us today. This will be very helpful for our viewers.
Julie was always a voracious reader. She'd carry 2 novels on an airplane because she'd read one on a 3-4 hour ride. And at some point, I began to notice that she would read a page and couldn't remember what she had just read, and she'd have to go back and read it again.
I don't remember much these days after I read, but less does for me, and I love it.
Everybody has a dream. Mine was to see the ocean. And with a little help, I made it.
They call me Prince like I'm royalty or something. But the places I've lived ain't no palaces. So I don't need grilled salmon or a new scratching post. Just give me a cardboard box and a can of tuna and we're good. You can even change my name. I'm cool being the kitty formerly known as Prince.
If you love them enough to relearn math so you can teach them math, then surely you'll check nhtsa.gov/the-right-seat to make sure they're correctly buckled in the back seat.
Twinkle, twinkle, little star.
Thank you for watching On Point. You can follow us on our social media at CSUN On Point. You can hear us on KCSN 88.5 FM on Sunday mornings at 5:30. You can watch us on Santa Clarita Television and on LA 36 with producers Coley Hooper, Gina Wong, Desiree Leon Rosales, and moderator Alexia Mersola. I am Mohammed Asad.